Welcome to Managing the DC FOIA Process, presented by the Office of Open Government. My name is Anthony J. Scerbo, and I'm an attorney advisor here with the office. I am joined today by my colleagues, and I see that we have a number of officers online joining us as well. We will be doing a social gathering at Stan's Restaurant on Vermont Avenue after today's training. So if you are joining us today and you feel like joining us to sit and socialize a little bit and get to know each other, we welcome you to join us there. We are going to be presenting a number of FOIA trainings throughout the spring, and then we will be moving into our annual FOIA webinar series. We will be sending out the schedule for that, as well as putting it in our next newsletter. So keep your eyes open for that. And as always, if you have changes in your staff as to who has FOIA officer responsibilities or Open Meetings Act point of contact, please do send us a message at openoffice.gov. With that said, I'm going to begin talking a little bit about who we are and what we do. This is my contact information. I'm an attorney advisor with the office. OOG is part of the Board of Ethics and Government Accountability, which handles both ethics and government transparency. They advise the district government on FOIA generally. Bear in mind that the Office of Open Government does not have enforcement authority relative to the DC Freedom of Information Act. We are advisory. On the other hand, to contrast, as far as the Open Meetings Act goes, the Office of Open Government is the enforcement office, and we do provide guidance and enforcement of the Open Meetings Act. As far as our role in the implementation of FOIA, we provide general advice up to and including the issuance of advisory opinions from the Director of Open Government and our Chief Counsel. And we're advocate generally to ensure that the FOIA process is fair and fairly executed according to the law. We do trainings, as I mentioned, and advisory opinions. And we will assist members of the public if they reach out to us, although, again, we always do that in concert with the FOIA officers and agency heads. We don't try to intervene unnecessarily or put ourselves between the public and the agency. Next slide. You can skip that one. All right. So the District of Columbia Freedom of Information Act. We're going to talk about responding to requests. We're going to talk about managing the process, and we're going to talk about after the determination what steps occur. Next slide. So the Freedom of Information Act of 1976, also known as DC FOIA, requires DC agencies to proactively provide certain information. Most agencies in DC currently have a Open Government and FOIA page or a subpage on their website. That is where the proactive disclosure material is normally located. OOG has been in the process of consulting with all the district agencies to make sure that the proactive disclosure material is caught up and is current. Any FOIA officers on the line who need assistance or want help with getting their material up to speed can reach out to the office, specifically myself, and we will assist you. We also, as a government, have proactively released hundreds of, if not now thousands of data sets, which are available on opendata.dc.gov. There is a lot of FOIA information from agencies that is already located there. So for those folks who are directing researchers, journalists, scholars, students, there is already a lot of information there. And if you're not familiar with opendata.dc.gov, I recommend that you take a moment and familiarize yourself. Next slide. So as far as the public records laws in the district, we have laws concerning the freedom of information, including the proactive disclosure requirement. We have the statute, which is a DC Official Code 2-531, and we have the regs. in the DC municipal regulations. The DC Freedom of Information Act gives any person the right to request records in any form that are prepared, owned, used, or in the possession of and retained by a public body. It's a broad statute. It was meant to mirror and reflect the time that it was enacted and to reflect the federal FOIA statute that was enacted at the same time. When FOIA requests are submitted, agencies are required to make a reasonable search for records. And on an annual basis, the district government, which includes the administration, the Attorney General's office, provide an annual FOIA report on the activities of all DC agencies. Those materials have been released in the last couple of months. The director alluded to it in the last beta testimony, and we released that information in our latest newsletter. So feel free to check that out for links to take you to the annual FOIA reports. Next slide. So there is no one central body within the DC government that handles FOIA requests. We are the advisors and we are the trainers, but each district agency invested in their agency head has responsibility for fulfilling their obligations under DC FOIA. They have the ability to delegate authority, but not responsibility to a DC agency FOIA officer. As far as the FOIA process, each agency handles its own. And then when you get to the post-determination period, there are one or two options available to a requester if they are not satisfied. One is administrative review via the Mayor's Office of Legal Counsel, or the MOLC, which handles appeals. DC Office of Attorney General handles FOIA litigation through the Civil Division. As far as agencies who have lawsuits involving freedom of information, Kevin? No. Okay. And so there are many players in the process. Appeal goes initially to the MOLC for administrative review, but it can also go directly to Superior Court. We'll talk about that a little bit later. And we'll go to the next slide. I just mentioned the Open Government Advisory Group. That group hasn't met in a while, but it is constituted of the different officers and players who have direct or specialized experience and knowledge of information and records retention and freedom of information. The director of Open Government, for example, is a member of OGAG. There's a member from the mayor's cabinet, member from the Attorney General's office, et cetera. Let's talk about the agency's FOIA responsibility. So each agency has to post the name, title, address, telephone number, and email address of its designated FOIA officer. That's an example of one of the requirements under the proactive disclosure requirement under DC FOIA. In this recent, I won't use a legal term, in this recent review that we've done with agencies of their websites in terms of proactive disclosure, for example, we discovered a lot of agencies were merely putting FOIA officer or an anonymous FOIA inquiry email on their FOIA page. That is not acceptable per the requirements of the statute and the regulations. The name, the title, the contact information must be there for the FOIA officer. It doesn't have to be for every FOIA officer. It just has to be for the primary person. If there's a multiple person staff handling FOIA, not every person's name has to appear, but the designated FOIA officer by the agency head does have to appear. They're responsible for tracking, managing, and responding to the FOIA requests. I think everybody that's present and everybody online that's joining us today either are FOIA officers or have direct FOIA officer adjacency. This is the meat and potatoes of what we do. They handle the intake, they handle the review, they handle the search, they handle redaction and exemption analysis, they handle the determination, and they handle fulfillment. It's a multi-step process, and it's obviously a very complicated one at times, and it's a major lift. So we appreciate everybody coming out to attend and to continue training on FOIA. The FOIA officer has to conduct or coordinate a reasonable search for records and respond to timely requests. The standard here is reasonableness. The reasonableness of the search. It does not have to be that every person's desk is searched, that every file cabinet is scrutinized. It has to be based on your records, your knowledge of your system, your knowledge of the staff and your processes, a reasonable search for the records requested. Next slide. Now let's talk about the request and requesters generally. Next slide. Unlike a neighboring jurisdiction like Virginia, where the Virginia law requires that a FOIA requester, or let me rephrase that, a FOIA officer only has to respond to a FOIA request by way of a request from a Virginia domiciliary, which means a body, an entity, or a person who is resident in the state of Virginia. DC is not like that. Our statute requires that any person, and that includes organizations, anonymous entities, et cetera, has the right to inspect and at their discretion to copy any record of a public body except under the exceptions, which are under 2-532. And that requirement is at 2-532A for anybody who needs to cite to that in a determination. Next slide. I'm going to allude to GovQA. We'll talk about it a little bit later for those FOIA officers whose agencies use GovQA and or who prior used FOIA Express. Yes, the district does have a contract by way of the Office of the Chief Technology Officer, or OCTO. However, FOIA requests can come legally and must be addressed in any way of the following. A request for agency can be made orally, means somebody in person or on the phone, or in writing, and must be directed to the particular agency. A requester then can be asked to submit a request in writing. So an agency does have the right to say, okay, we've heard your request, we will acknowledge it. Will you provide this request in writing? Request can be mailed, faxed, emailed. I know most of us don't get faxes anymore, but that is still a legit way, and there are still people who send e-faxes, and that is still a legit way to submit. I speak personally, and I think I speak for several people I see here. I still get handwritten FOIA requests from people, for example, who are incarcerated. The only way they can make that request is by hand on a piece of paper, put it in an envelope, and mail it. So it still does happen that we do get hard copy snail mail requests. Next slide. So I mentioned that we not only are governed by the DC FOIA statute, but by the regulations. 1 DCMR section 400 and what follows contains the rules and procedures to be followed by all agencies of the district. When you go to our website, post after this, not today, because we probably won't get it up today, but tomorrow or going forward, you'll be able to access this link either by our website or from this deck, which will be posted on our website, and you can then immediately go to the relevant regulations that are applicable. A trick that I tell people to do, because it's very cumbersome to go to the DCMR section of the DC page. There's a way to right-click and print, where you can print all the regulations into one PDF document and have them all handy, instead of having to go in and download individual subsections. Anybody who has trouble with that, reach out to me, and I'm happy to guide you through that process. Next slide. Let's talk a little bit about the request. The request has to be specific. There is a requirement for specificity. It must reasonably describe the desired records, and if possible, specific information regarding names, places, events, subject dates, etc. The information, the meat of the detail, shall be supplied. And that's required in the regulations. I think probably every FOIA officer I've talked to for any length of time has gotten a mass, omnibus, or blanket request of some form or another. Yes, you still have to deal with them. Yes, you still have to work with the requester, but the reg also provides you that a request has to reasonably describe the records that are being sought. And you still may end up with an omnibus type of request, but you do have latitude to rely on the reg to try to drill down on the specificity and narrow a search. Next slide. Let's talk about things they can ask for. I mentioned before all the ways they can submit. They can look for emails, text messages, notes, databases, files, communications, video footage, camera footage, photographs, structured data, etc. We keep an eye nationally on news related to government transparency. And what we're seeing nationally is that a lot of places, people were under the misapprehension, oh, my email is exempt. Oh, the text messages I had were exempt. The ephemeral messaging app that I use, that data is not, no, it's all subject to FOIA. And that up to and includes if you use your personal device for government business, that information is still subject to the Freedom of Information Act. Next slide. All right, so what's public record under FOIA? Public records is defined in the DC code. I'm not going to go into the deep dive. We'll go to the next slide, give you just the top line. It's pretty broad. All books, papers, maps, photographs, cards, tapes, recordings. I'm old enough to remember tapes, data tapes, vote data, including ballot definition material, raw data, ballot images, other documentary materials, regardless of the form or characteristics, owned, used in the possession of or retained by a public body. I don't know how much broader you get than that. So bear in mind, the default is if it's in the government's possession and it's information of some form, it's probably a public record, and you work backward from that to whether something's exempt or not a public record. Electronic format now includes text messages in some applications. I don't think that there's a current case in DC, but I know of at least one in another jurisdiction where Teams messages are considered records. So bear in mind that I'm not aware of a threshold where the court's not likely to find that something that's used to communicate information in a government space is not a public record. Next slide. Within the statute, if a government contractor is in the business of providing a government or government adjacent service under a contract to the government, then their records in pursuit of that contract are probably considered in almost every case any record produced or collected pursuant to a contract to perform the public function. Now, that said, those companies do not have a FOIA obligation. The contracting agency of the district government has the FOIA obligation. So if you are agency A and you are in a contract with subcontractor B, you are responsible for any FOIA request that comes in regarding their records in their performance of the public function under that contract. And again, if there are questions, feel free to reach out to myself or one of my colleagues and we can advise you, but that is in the statute specifically. Next slide. I talked before about the proactive disclosure. Yeah.
What do you do in a situation where you have a third party that may say retain some sort of database or something on behalf of the agency, and then at some point maybe the agency moves on to a different third party or a different provider, and sometimes that material now may not be captured or may be lost? What should an agency really do in those situations if they receive a FOIA request for that material later on down the line?
Thank you for the question. Okay, so for the folks playing the home game, I'm going to just recapitulate the question as I understand it. Agency A has a subcontract or has a contract with a subcontractor. They maintain some form of either proprietary database, data set, bank of records or information. At some stage down the road, subcontractor B stops being the provider of that public function or service to agency A, and now it's somebody else. What happens? The FOIA officer and probably the records officer, which are two separate designations in DC agencies, who work for the agency, need to ensure that any contract that they have with a vendor clearly understands that that data does not belong to them, the contractor, if it is in pursuit of the public function. And those records have to be maintained according to what's called the record schedule. Now, your records officer knows and is trained and deals with the archives and those policies. The base standard number is 5 years. And absent other information is what we advise. Many agencies have longer periods of record retention for one reason or another. You have to get into your enabling legislation or mayor's order or things like that. But generally speaking, the agency is responsible, even post the, to secure either a copy or to ensure they have continued access under the district FOIA to that information. I don't think I've ever seen a situation, and I'm only speaking anecdotally because I can't give you a legal opinion on this in an absolute sense. I am not aware of any contract that would absolve the contractor from providing that information, because the contract would be structured such that because they're performing a public function for a government agency, that information would continue to be available. But my advice or my advising would be you need to set that out in your contract, and you need to make sure that your records and FOIA officers and agency head are all tracking the fact that that data continues to be subject to the district's Freedom of Information Act. Does that answer your question?
Yes.
Okay. I have multiple hands. I'm going to start here.
Me?
Yeah.
I mean, I don't know.
Yeah.
Let me just ask, anyone who's actually here, when you ask a question, could you identify yourself?
Okay.
Simply because, people online who are asking questions, we got their names.
Well, you know what? Maybe I don't have a question. You said what it should be. In my particular situation, my name is Jessica Darby. I'm the FOIA officer for licensing and consumer protection. We had a situation where that wasn't the case. I know where you said it should be, but it wasn't the case. However, we have come far and long enough to where I can lean on the agency retention record now. I mean, retention schedule now. But,
Okay.
So I guess I don't really have a question.
Sure. Well, and so you made us aware of the fact that there was at least one example where something fell down. That's not to say that it couldn't have been recouped or in some way accessed via litigation, et cetera. But, obviously that's not the goal. The goal is to have a seamless record and access to information experience. But thank you for sharing that. I think we have a question coming from online.
Yes, Anthony. Any consideration to amending geographic who may request? Responding to requests from Ethiopia is of limited utility for promoting local transparency. So,
Okay, I take the questioner's point. I will make a couple of points. One, the Office of Open Government is here to serve government openness and transparency. We don't write the statute; that is done by the council. So that's the proper forum in that sense for amending. We don't amend legislation. We just assist in implementing it as it exists. And I will say, there are people in far-flung places who are scholars, researchers, journalists, et cetera, who do need to access information for the work that they do. We try to encourage where there isn't a need under an exemption or a protection or a common law privilege to provide openness, because that is, according to what is called the preamble and other parts of the district of the DC official code, the public policy of the district. I hope that answers the online questioner's question. I see another hand. Okay, we'll move ahead. Next slide, please. Oh, sorry, let's stay here. This is an example. 2-536 is what I've alluded to several times about proactive disclosure requirements. These are the majority of the requirements. For example, employee salary, title, and employment dates. A link to DCHR's online searchable database is sufficient to meet that requirement. Contracts expenditures. OCP, a link to the Office of Contracts and Procurement, sufficient. Budgets, link to your budget documents online. Manuals, policies, rules, opinions, and orders. If your agency is one that has those things, if you have manuals for dealing with the rights of the member of the public, et cetera, put a copy of it up or put a link to where you have them up somewhere that members of the public, and that means anybody anywhere, as we just discussed, can access them. And then meeting minutes of open proceedings of public bodies. This is that one place where we cross over from our advisory role in FOIA to our enforcement role as the enforcement agency for the Open Meetings Act. Per DC Official Code 2-571, where the Open Meetings Act is, your meeting minutes of proceedings of public bodies do have to be posted. And I encourage and advise anybody who's not their open meetings point of contact to feel free to attend one of our Open Meetings Act trainings where you'll find out all about those requirements. Next slide. All right, responding to FOIA requests. Next slide. All right, so we're now getting to the timeline. FOIA officer receives a FOIA request. You might get it from GovQA. You might get it in the mail. You might get it by phone. We already discussed that. You acknowledge receipt of the request to the FOIA requester. If you need help, there are examples, and I'm happy to work with anybody, as are my colleagues, to help them come up with, if they don't internally already have an acknowledgement letter, we can help you come up with that. The GovQA system, I think by default, if you're getting a message by that system, unless you disable it or turn it off or what have you, which you would contact Okta to do, it will send an auto-generated generic acknowledgement once the request is submitted into GovQA. The FOIA officer should assign the FOIA request an internal tracking number or use an internal system. Again, the GovQA system does that. So if it comes through GovQA, there is already an auto-generated number. If, for example, that I used earlier, you get a handwritten request from someone who's incarcerated. I have an internal system as big as FOIA officer that I assign a number to that, so I know that it came in by mail and that I have a way of tracking it, because, as I mentioned, for the annual report that comes out from the Attorney General's office and the Mayor's office, I have to submit an annual FOIA report, which will include numbers and the data regarding those requests. Next slide. And by the way, FOIA requests are records which can be FOIA'd. So the other reason is you have to be able to keep track, because your FOIA records can be FOIA'd themselves. So the correspondence typically includes the following things. You're looking at, the introduction and acknowledgement. I'm the FOIA officer. I received your FOIA request on such date. Here are the rules, the statute that we fall under. If you have clarifying questions like, okay, you asked for X, did you mean Y, or did you mean X plus 2 or X minus 1? If it looks like fees are going to be involved, you would go to the regs and you would look at the regs and you would indicate the potential for fees and make the requester aware. Processing track designation, not a big issue. Contact information for questions. Again, the FOIA officer's direct contact information should be on their website, but in your acknowledgement letter, you say, here's who I am, here's how you contact me, here's the best way to contact me. Written signature and a type name and agency. Yes, /S/ is still a written signature, but you do have to acknowledge that you submitted your response. And I've got a question in the audience.
Good afternoon.
Good
My name is Tanya Condell. I'm the FOIA officer with the Department of Housing and Community Development. So when the Gov FOIA database sends out the automated acknowledgement, are you saying that the FOIA officer or the team member assigned that FOIA has to send out another acknowledgement?
No.
Okay.
And thank you for the question, for something that I would not have thought. So now what I will say to that, and I'll again repeat the question just in case it didn't get fully picked up. If the GovQA system is all ready and you, the FOIA officer, know it's already sending an automated response, so long as you, the FOIA officer, have reviewed that automatic response, because as I said here, a discussion of fees if possible. So if the automated acknowledgement doesn't discuss fees, and you think fees are likely, then you haven't informed the person. If you have follow-up questions, if you haven't included your follow-up questions, how does that boilerplate piece of acknowledgement help you? It doesn't fulfill your role and your requirement under DC FOIA. What I am saying, however, is you do not have to do a separate one if the one you see got generated meets all the requirements that you as a FOIA officer have to properly acknowledge and deal with the request. It might, but you still have a duty to ensure that is the case. I will tell you, our system, I believe, generates the other one. I send a separate acknowledgement to all of my FOIA requesters. And I tailor my response from a general template. I specifically address all of these issues in each of my acknowledgements. Sometimes they look, sometimes 3 in a row, almost exactly the same, except for my captioning what it is they're requesting. Other times I got questions. I got to let them know, hey, it shows that you're $500 in arrears for the district for prior FOIA requests. I'm not going to be able to fulfill this until you get caught up with, with your bill, et cetera. But no, if you have a system in place and you know that a FOIA requester is getting an acknowledgement and you view that acknowledgement as sufficient to meet your requirement, then no, you do not need to send a separate acknowledgement. Great question. Next slide. So, timing. For records other than body-worn camera recordings, 15 business days is the statutory limit to fulfilling a FOIA request. Body-worn cameras being the exception, there's 25 business days, 5 calendar days under certain cases. I don't think I see any of my MPD folks here. I'm not going to get into body-worn camera specifically. If somebody wants to discuss that offline or has specific questions, follow up with me. It is the exception under DC FOIA, and there are obviously separate considerations for that. But anything other than body-worn cameras, it's 15 business days. And we'll talk here in a minute about the ability to extend under what are called unusual circumstances. Next slide. In, quote, unusual circumstances, the agency can invoke an additional 10 business day extension by written notice to the requester, setting forth the reasons for the extension and the expected date for the determination. It is a by right. If you have determined that unusual circumstances exist, you don't have to get somebody's permission. You just invoke the 10-day extension. But you do have to, in writing, notify the requester of those two things, the reason and the expected date for the determination. Now, I used to be a legislative director here in the city. I love language. Unusual circumstances is one of those things that causes an old man's head to hurt. Next slide. Let's talk about the zone that unusual circumstances comes out of. What exactly are unusual circumstances? Next slide. So unusual circumstances are defined in the statute. So in DC Official Code 2-532 D2, the need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records that are demanded in a single request. I hate to tell you, voluminous is not subdefined in this case. So again, somebody who loves language, and or the need for consultation, which shall be conducted with all practicable speed with another public body having a substantial interest in the determination of the request or among 2 or more components of a public body having substantial subject matter interest therein. That means the records that are being requested don't just apply to you, but apply to another agency, or they came from the other agency and they're originally their records, etc. Then you are in unusual circumstances territory. Voluminous, that is up to the discretion of the interpretation of the FOIA officer. I think, an easily hour or 2 quick search, electronic record search, et cetera, is not going to qualify as voluminous search. But however, if you know that the records are going to require common law exemption analysis, a redaction, the FOIA exemption analysis, et cetera, then yeah, that's factored into the voluminous records, because you're going to have to look at every one of those records to do those things to comply with the law. Next slide. So for body-worn camera, again, this deals with the ability of, because the agencies that use body-worn camera do not do the processing 99 times out of 100 themselves. So this just affects where the vendor. So again, if somebody has body-worn camera questions, I'd rather deal with that offline, because it's a very specialized niche. And there's even, again, the case law is also very specialized. So next slide. would take it. You just use the automated system, the feature's there. You go into QA, you can click on it, you can then save, and then it will do the thing and it will notify the requester that you have invoked the 10-day extension. If you're outside the system, kind of like what in many cases I do, where I've sent a letter, I will also send them a letter via email with it attached and in the body of the email letting them know that, we're in unusual circumstances territory and that we've invoked the 10-day extension. Doesn't have to be a lot of words. It just has to be legally sufficient to inform the requester. Next slide. So if you don't respond to the FOIA requester, and by respond, I mean determine, not the acknowledgement, although you are supposed to do your acknowledgement, but if you hit the 15 business days post the request, and the request does not start because you acknowledged it, it starts the day you received it. So if it comes in Friday night at 8 o'clock, we treat that as it's a Monday morning request because you're not on your tour of duty at 8 o'clock in most cases on a Friday night. So that request is received when you start your tour on Monday morning in a normal week. So from that day forward, you have 15 business days. Whether you acknowledge it or not, that's still that clock ticking. If you do not respond to a FOIA request on time, then that is what is called a constructive denial of that request. At that point, the rights of the requester are triggered to either do an administrative appeal to the MOLC or to file a suit in Superior Court. They can do that in order by doing a MOLC appeal, waiting on the appeal response, and then filing a suit, or they can circumvent the administrative review entirely and go straight to Superior Court and file suit. Next slide. And next slide. Problematic FOIA requests. As I said, sometimes they're very easy and those should be taken care of as practicably as possible and done, but we all get problematic FOIA requests. If you receive a request that is overly broad, then under the regs, a request shall reasonably describe, etc., where possible, and I already used this verbiage once just so to reinforce the point. If you receive a request that's overly broad, next slide, where the information supplied by the requester is not sufficient to permit the identification and location of the record by the agency without an unreasonable amount of effort, again, another word that is subject to interpretation, the requester shall be contacted, not might be, shall be contacted, and asked to supplement the request with the necessary information. Every reasonable effort shall be made by the agency to assist in the identification and location of the assisted records. As our director has said in advisory opinions, testimony, training, and every day that we meet here in this building, it is a collaborative effort. We are working with the requesters to fulfill their requests legally, sufficiently, and to the maximum extent possible. Next slide. How does it impact my deadline if a requester refines the search? So once again, in the regs, not the statute, a request is deemed received when they receive the request submitted in compliance. However, when you contact the requester, according to 1 DCMR 402.5, for additional information, the request is deemed received when you get that additional information. So there is a tolling that occurs once you have communicated with the requester and said, I need clarification. At which point you stop counting your 15 days and then you resume it once you receive that information. But when you receive that information, the tolling is in fact over. Next slide. What if they never respond? It happens. It's happened to me, and I think it's probably happened to most everybody in this room and online. The advice we've given in the past is to contact the requester at least 3 times, 3 separate times before closing a request for lack of responsiveness, and then therefore assuming it's abandoned. We suggest that you do it 2 weeks between each time. Something happened, they're not able to access their communications, medical, personal, whatever. After the 3rd contact in the 2-week time span, then administratively, we advise that you close out the FOIA request if no response and assume the FOIA requester is abandoned. Make a note of this in your files and your records because, again, it comes up in your annual report, et cetera. And keep a note of this because, again, your FOIA records can be voided. Next slide. What if we get overly burdensome request? And by burdensome, I mean the burden on the agency. Unfortunately, there's no what is called term of art, void for volume in the district. There is no authority to treat as void requests that the district believes are overly burdensome, and that comes directly out of the case FOP, Metro Police Labor Commission versus the District of Columbia. I know that case is available online because I've not had access to my ledgers and I've still been able to pull it up. I also believe it's posted on our website, but if it's not, you can reach out to me if you can't get it, and I'll get you a PDF of the case. Next slide. Voluminous email productions. If you have to review.
You have a question.
Oh, okay.
Hi, Tanya Condell again. So I know we do not have anything in our FOIA regs about voluminous or burdensome, not voluminous, but burdensome requests. Are we trying to change that? Are we making any?
Okay. When you said our, you mean the districts, right? We're all okay. Again, I'm going to punt. The Office of Open Government is for transparency writ large and generally. Any change that comes to that needs to come from the public, the leadership of the city. We do occasionally engage in rulemaking. It's fine-tuned rulemaking. It's meant to improve the process, meant to improve the experience, et cetera. To do a large-scale change like that, it has been felt all along that that is a political decision that should be made by the politically elected decision makers. So although it's frustrating and it does make things difficult, we have not on our own or sua sponte pushed that type of a change. Our recommendation is always, where your pulpit exists, where this thing exists, your performance oversight, your budget oversight, your meetings with with the council members and your committee chairs. That's really the place to talk about this. This office, through our director, provides testimony. We have our monthly reports to our board, as well as our director and the Office of Government Ethics director go and they testify before the council. And we make them aware of our concerns and our recommendations. But, what we don't want to do is try to engage in political decision making. Great question. So if you do have to review a large number, it may take longer than 15 business days. Yes, at that point, you are constructively denying a FOIA request. Spoiler alert. However, if you contact the requester and work on a production schedule, most requesters understand, as long as you're working with them, that some things take more time than the statute provides. We recommend that you attempt to produce a first batch within the 15 days, and then, according to a schedule agreed upon, continue to fulfill the request until it is fully fulfilled. It is still technically denial, and they can appeal, but you're acting in good faith, and unfortunately, there's no remedy because the denial for being burdensome on government resources is not a legitimate basis for slow rolling or denying a request. So, next slide. And next slide, the search. All right, now we're talking about the search. The ultimate responsibility for DC FOIA falls on the head of an agency. As I said, they can assign authority to the FOIA officer to be responsible for FOIA requests. However, that person is the point person and the primary. All agency employees who maintain records nevertheless must assist the designated FOIA officer as appropriate with the identification and search for responsive records. I know because I've heard it from people that it's very burdensome or difficult because people say, not my job, not my problem. That's your job. They are wrong. The reg is right there, 1 DCMR 401.5. I know that people don't want to have uncomfortable conversations, but you are standing on the law when you say it is your duty and responsibility to assist in identification of these records. If a FOIA officer has a major problem with this, where they're getting a lot of pushback, my recommendation, and I think all my colleagues' recommendation is talk to your agency head and make clear that the culture needs to understand that it's the law, and the requirement of the law is that all agency employees, not just the FOIA officer, are responsible. Next slide. So at the beginning, each agency should have a records officer who is designated responsible for the records. You look at your work chart, you look at your workflows, you look at your process, and you determine where are the records requested most likely to live. Where do they do their moving? Where do they transit from a director? Do they transit from a section chief, et cetera? Who has those records and where do they end up? You do that analysis. If it's emails, then obviously go to the chief technology officer or Octo, and you do what's called an ERS or electronic record search. If you're not familiar with that, reach out to Feng Nguyen at Octo, and he can get you set up with an account to submit ERS requests. We don't handle that or process those. But like I said, you're not going into other people's cabinets. You're not unlocking people's file cabinets, things like that. You are identifying reasonably where these records are. You're then planning your search out. You're contacting the people you need to contact. You're saying, here's the timeline. Here's what I need. Here's what's been requested. And you're dialoguing. You're dialoguing internally, just like you're dialoguing with the requester. And then, make sure, according to the record schedule, if a request for a record goes beyond a certain point in time, the record may not exist in the agency. It may be archived, in which case that's a separate issue. That's a separate search. That's a trip to the archives. That's an email to the archives. So bear in mind, your agency is only responsible for the records that it's required to have, according, among other things, to its record schedule. Next slide.
Anthony, we have another question.
Okay.
I just want to make sure I understand what you're just now saying. So you're saying that your agency is only responsible for records that you're supposed to have according to your record schedule. However, if your agency has more records, like, you might get a request for stuff that's 10 years down the line, you still have to produce that, right?
So this is not for two answers, and I'm going to defer to my director if she so designates. My understanding is that a request for records from the archives is a separate request and is not a FOIA request. It is a request for archived records, because the archived records are not the property of the agency or the custody of the agency, they're the property of the district. Now, it may be that you are the person and you can go and you can make the request of the archives and then fulfill the records. But you don't have, as a FOIA officer, the same access to archived records that you do to your agency's records. So your timing and everything else is different. Say a 10-year-old record, if your records retention schedule says that you have records for 5 years and then you archive them, you can't access those records from the archives the same way you can access the records that are resident in your agency from 2 years ago.
What if those records aren't at DC archives, right? What if they're living at somebody's desk or in somebody's hard drives?
You do. So we're back to the reasonableness. The reasonableness of the search is that you have identified the people in the places where the record could be or should be, and you've searched for it and you've put out your thing. If it's resident on somebody's hard drive, not in their email, etc., but in their hard drive, you have reasonableness required. The requirement is reasonableness, not absolute. You are not tasked to go office to office and search people's hard drives. However, if you're talking about an archived record, that's separate. That's a different issue, because those records were tagged, bagged, identified, indexed, re-indexed. If you haven't done it, anybody here has not been a records officer, it's a very involved process.
That if your agency has the record, if it's in possession of the record, then yes, it has to produce the record, regardless of if it's in archives or not, how old it is. So if it's the 10-year-old record and the agency is able to get that record, it should produce it to the requester. So it's not an excuse per se that it's past the retention schedule. If the agency actually has it, it should produce it. But the corollary is it does not have to go to archives, as Anthony was saying, to get the record. if it's outside of the retention schedule and not at the agency. And yes, if you follow the procedures and send your records to archives, you have no obligation to go after those records. You refer the requester to DC archives.
Great. And for the plan online who can't see, that was Director Nick Allen, the Director of Open Government, and that was a much better way of phrasing it than I did. So at this point, we've come up with our game plan. We're in the process. What are you required to do? An adequate search for records, responsive, adequacy, reasonableness. Again, I don't want anybody to go away from any of our trainings thinking I am spending evenings going around everybody's computer and searching and then searching their Post-it notes. That is not FOIA. FOIA is adequate. FOIA is reasonable. In assessing whether the agency conducted an adequate search, they look to the fruits of the search, not to the fruits of the search, but to the appropriateness of the methods used to carry out the search. So if a FOIA request is made, a FOIA fulfillment is done, the requester then files a FOIA appeal. Your agency gets notified at the same time that the Mayor's Office of Legal Counsel or the MOLC gets notified of the appeal, and you have 5 business days to respond. You would then address the adequacy of your search in your response to the appeal. And the MOLC and your Superior Court will look to the adequacy of your search for whether or not you have, fulfilled your obligations. It is not a matter of, well, you didn't find anything, therefore you didn't do it, or you didn't do it right. It's not whether you come up with what somebody's looking for or what you came up with. It's whether what you did was adequate. The issue can be, resolved is not whether there might be existing documents was adequate. And again, there's the, I never say this right, either all day. I'm just going to go with that, versus the Comptroller of the Currency case in the DC Circuit that established that precedent. And again, I think I have a PDF of it if you're not able to find it online. Next slide. So how do you, and trust me, I'm the king of barely adequate. How do I conduct an adequate search? How do I get to adequate? It need not be perfect, only adequate. Adequacy is measured by the reasonableness of the effort in light of the specific request. I am looking for all emails from January 1st of 2021 to October 31st of the same year that mention the Cherry Blossom Festival. Okay, that's a fairly straightforward request. If you do an electronic record search of the people named or of the agency named in the request, that date range using words that you feel adequately deal with the Cherry Blossom Festival, Cherry Blossom Festival, etc., and you've done that search, I'm willing to bet that either authority will view that as an adequate search. If it's more involved, if it's more specific, if it's more esoteric, you may need to play around. Again, we always encourage that you consult with the requester to narrow things down, not just to make the request smaller, but to make the request clearer. But it's the adequacy and reasonably calculated to uncover all relevant documents is the standard, not the, you didn't come up with what I think exists and therefore you're wrong, because that's not how these things are decided, thankfully. Next slide. So you've done your search. You've come up with your game plan. You've consulted the people you need to consult with. You've submitted your online or in-person or physical requests. You've got to that point. You're now at the point where you're going to be doing your declaration. So your determination, when a requester challenges the agency search, the agency must establish beyond material doubt that it expended reasonable efforts to uncover all relevant documents. This is where you create an affidavit in response to the appeal or to the lawsuit, either the MOLC or Superior, and you do an affidavit that you did what you did and that what you feel you did met that standard. Again, there are perfectly good online examples of how to phrase or frame your affidavit. But the point is, this is why you do your search adequately and properly to begin with, because you're going to probably or possibly be put in a position where you're going to be doing an affidavit to attest to that fact. Next slide.
Yeah, question.
Got a question? Okay.
Hi, Tanya Condell again. For the affidavit, if I am dependent on the division to produce the documents for me to review, and they say, hey, we don't have anything, and I tell the requester we do not have anything, and then they come back and like, well, you do have something, I will go to the division for the affidavit.
No, you're doing an affidavit. This is why, if your requester says you have something and your division says you don't, somewhere earlier in our steps, you need to find out why requester says you do and division says you don't. If your division says, I'm showing you, I'm telling you, then there's no reason you can't do an affidavit. And then what we have to figure out is, why does the requester insist or think that you have a record that's not produced? Just because somebody believes the record exists does not mean it exists.
Mhm.
And that's, but if the requester says, here's online evidence, here's a document, here's something from testimony at a performance oversight hearing, et cetera, which has happened, where she says, we don't know what you're talking about. Well, here, what are you referencing right here? And then somebody goes back and looks and says, oh, yeah. Or, oh, yes, apparently we do. We didn't look for it that way. The adequacy and the reasonableness has to be at your, as the FOIA officer, you are the tip of the spear. So you have to be pushing. If somebody just said, no, we don't have it, and you've got a requester that says, yes, you do, you know, that requires further follow-up.
And a follow-up on that is, so we have a FOIA team, so it's FOIA officer and then paralegals. And so even as the FOIA officer, even if they do more to search the conversations and going back and forth, I will still have to sign the affidavit, or will they sign the affidavit?
Yeah, I'm going to defer to the director.
Okay, good. Well, let me back up. When you're talking about an affidavit, that's more of a legal document for litigation. You should probably do a declaration. A declaration is just a signed statement of what happened in the process and the agency side. So that was like a pre-litigation document. So in the scenario that you gave, where you have a paralegal who's doing some work, you're doing work as a FOIA officer. If your agency would like to keep a record of the process, then both you and the paralegal could do a declaration of what you did. So that's on the record for the agency. And you would do that as a matter of business practice. If it got to litigation, then OAG or whoever's representing the agency would dictate likely who is going to need to do the affidavit.
Thank you.
You're welcome.
And I don't know, I know from the microphone that we're getting a little static or whatever from the speaker. Anybody feel free to let me know if anything can't be heard or needs to be repeated. Happy to do so. Next slide. Oh, I'm sorry, we're on the rest. Next slide. So, you know, what should it include? Context for the request. You're describing the structure of the agency's file record keeping system. You know, do you have a retention policy? By the way, every agency is supposed to have a retention policy. I know at least one or two district agencies that have them, but nobody on staff knew. The record officer knew, the agency knew, but nobody else on staff knew that they had a retention policy. Every district agency has a retention policy. The archives and the secretary's office are pretty on that. They make sure to identify. And then was a search conducted, even if the retention policy called for the disposal of the record? Just because it called for the disposal of the record doesn't mean the disposal happened. And that is a step. That is a FOIA officer step to determine, well, okay, we're outside of this period, but does the record still exist? You're still needing to check and verify whether that record still exists within the agency. Next slide. You have to describe at least generally the structure of the agency's file system, which makes further search difficult. This again is from a circuit case quite a while ago now. I think it's about 40 years. But Now that we are electronic and digital to an infinitely greater degree than the time of that case, nevertheless, you would need to describe generally, we have hard copies that we maintain thus in file cabinets thus. We maintain a shared drive where we do the following. We have a proprietary database where the following records go, et cetera. As long as you can do that generally, that is sufficient come the need. You do not have to, give away the story, and you certainly don't ever want to provide information technology, security compromising information or anything to that level of detail. Next slide. So, explain how the search was reasonably calculated to uncover all the relevant documents. You would document your steps, which is why when you get the request, when I say come up with your steps, come up with your game plan, you probably should at least outline your game plan of what you're going to do. Because if you get a FOIA appeal, you have 5 business days to respond fully to that FOIA appeal. It is much easier to go back to your notes and go, this was my outline, these were the steps I followed, and these were the results, than it is to try to remember and try to reconstruct what you did. Additionally, both how the search was conducted and why you did it the way you did it. I think most FOIA appeals responses, I'm weird, I read a lot of them. I read a lot of the things that have come out from appeals. Most responses are not 800 pages long. So, the appeals process works just fine with FOIA officers doing a brief description of how, a brief description of why, dealing with things, and then stopping. You do not have to justify, you don't have to go into a lot of stuff. And if only one system is searched, make it clear the system was the only possible place. Okay, we have operators, they get calls, they put the information via an online system into this database. The only place this record from this phone call could go, for example, Office of Unified Communications, is this database. Then just say that. But you do need to make that clear. The reason I didn't go to the file cabinet at the old warehouse is there's no way a phone call to this system would result in a record over in the old warehouse. Then you say that and you're done and you move on. Next step. Email searches. I alluded to this a little while ago and a couple of times. We do not know, I'm quoting here, we do not know and cannot simply assume in this age of computerized connectivity that it would be unreasonable for the agency's FOIA officer to search all of the agency's email accounts, regardless of how many accounts that might be. And this is that same DC Circuit case from 20 years ago. If you haven't used the ERP system, it is lean, it is spare, it is straightforward. It will do what you ask it to do. You designate the email accounts, you designate the date ranges, you designate the words, phrases, et cetera, using what are called Boolean connectors. For anybody who doesn't know, that's and, not, but, et cetera. And you frame it that way. Octo is pretty good. Octo will get back to you if your response is generating a massive data set. They're probably going to contact you and go, are you sure this is framed or phrased the way you want it to? If not, they're just going to deliver your results. Now, bear in mind, it's not a quick system all the time. Sometimes you'll put it in, say, on a Monday. You might get a response by Thursday. But bear in mind, your 15 days are tolling. So if you identify that an electronic record search or email search needs to occur, you want to factor that in early days in that outline of yours and get that started. Because if you have to refine, that refinement may then take more. Although generally the refining process is much quicker in my experience. Next slide.
You have a question?
I got a question from the audience.
Danny Patel with PhD as well. Are we allowed to stop the clock when we submit an Octo ESR?
No. I mean, I'm not aware of any precedent or basis for that. The ESR search process is, to my knowledge, considered part of the 15-day time frame. If you're aware of something, or if somebody else is aware of something, that would be great because you'd make every FOIA officer in the city very happy.
Well, there have Email says it takes 2 weeks to process unless you need an expedited request. So
In
that
which
kind of,
case you have to send an email. My experience, I've never had one take 2 weeks.
I've had many that
Many.
take more than 2 weeks
Okay. And
without an expedition.
yeah, and so therein lies the taking us kind of full circle back to the question of, things that we'd like to see changed long term. I'm certainly as a FOIA officer for it, but again, that may be a political decision that needs to be made in terms of making an adjustment to say if we're dependent on our email service provider to do this, and yet we're on the hook 15 business days in. Yeah, I mean, I see where, and a lot of FOIA requests become constructive denials, and we see a lot of things go to the mulk. But in and of itself, as far as I've ever known, the ESR is part of the 15-day process. And to the very good point that was just made, you would invoke the unusual circumstances and get your 10-day extension because of the fact that, per your point, if you've identified that you're dealing with a voluminous number of records, then you are eligible for your 10-day extension. However, and I think my memory on the 2-week statement by ESR, the ESR system, it doesn't. I think that in the context they say it's 2 actual weeks. We're
up to
2 business weeks. I mean, 2 weeks. The 15 days is 15 business days, as is the 10-day extension. So again, we're getting to where, there may be a little wiggle room and overlap, but by all means, you should be invoking any available extension if you're dealing with that volume. I've been fortunate, one way or the other. Most of my agency's requests, I'm able to narrow. I have had to invoke extensions, but and certainly we've had situations where we've had to toll because we're waiting on clarification from the requester. But if you've had a lot of those, then I would fine tune your process and say, you get your 15-day, you determine that it's going to be probably that period of time, you immediately invoke and notify your requester that you're invoking the 10-day extension. And that way you've got the 25 business days ahead of you. Because again, it's by right. You've determined, if you've made determinations, unusual circumstances, then you can invoke the exemption, but the extension. Great question. Next slide. Oh, we're on the next slide. So how many email accounts exist, what the agency capacity is in searching for them. You can consider having Octo submit it to the director's point to the declaration if it gets to that point. At least at the MOLC level, the Mayor's Office Legal Counsel level, they're aware of the DC operating environment. For litigation, to Superior Court, I would assume nothing and document everything and get every piece of whatever. I don't know that, and the MOLC or Octo is doing a declaration relative to a MOLC appeal, or how often it's necessary. Because again, the MOLC understands that, there was an ERS request put in. They're aware of the process and the time. You certainly can go request it. But I don't know that it's at the administrative review level that it's absolutely necessary. But it certainly will punch up your appeal response. Next slide. Fees. We get a lot of questions about this. The fee schedule, the fee rules are in the regs. The easy things, the process things are, as we discussed, the FOIA officer is the narrow point of the spear, but it's a team effort. Make sure that everybody and anybody who is assisting you track their time that is dedicated to the search. You can charge fees for conducting record searches and producing records. There's no fee to the request. Like the request does not, but you can require them to pay their fees in advance if they're past due on, their accounts with the district. A lot of requesters, especially I think in DC, I think maybe in other places it's not as common. So many of our requesters are journalists, think tanks, universities, students, private citizens working on a research project, et cetera. You're going to see more requests for fee waivers than you're not. But bear in mind, don't assume, because we also get plenty of requests from people who say, I'm willing to pay fees. And in many cases, they'll say, please contact me if the fee estimate is above a fixed number, in which case you would advise them on what you estimate that to be. So searching for records, review of records, the hourly rate is based on the pay grade of the person who performs the search. The photocopy is 25 cents a page. I'm sure there are people who still request hard copy records in a few cases. 95+% of the things that I get asked to confer about or that I see are electronic, purely electronic requests. Nobody's requesting, 25 cents a page hard copy records anymore. Could happen. And then certification would be $1 per document, et cetera. Again, a certified copy, that's probably always in anticipation of litigation or something like that. I'm sure there are agencies, and again, you can reach out to us or you can reach out to the FOIA litigators at OAG if you have specific questions. Flash forward teaser, when we do our FOIA webinar series later this year, the final session that we do every year is preparing for FOIA litigation. And it's presented by the litigators in civil division who handle the vast majority of DC's FOIA litigation. And that is a FOIA officer only training. So keep an eye out for that. And it's one of the best trainings of its kind I've ever seen. And I don't just mean DC, I mean, as far as FOIA litigation, it's one of the best I've seen nationally. And that is one because of the content that is FOIA officers only, or FOIA staff only, and that is one that we don't record and post. So you would need to attend that if you want the benefit of that. It's really excellent. So I would definitely recommend that. And bear in mind that even if there aren't responsive records, if the search is going to be massive or onerous, then the requester may still be on the hook for fees, even if there's not, just because they're not getting what they think they expect. They can still be on the hook for fees. All right, producing the records. And I'm going to start to move it along a little bit faster because we don't have to go over the exemptions at great length. Under the statute, we have the FOIA exemptions. So, the exemptions are and have been consistent with the federal law. There are more exemptions under DC FOIA numerically than there are under the federal FOIA at this point. A lot of them are very specific, or they're specific to one agency or one situation, and will probably never apply to any of us. So exemption 1, trade secrets and commercial or financial information obtained from outside the government. The test there is, would it result in substantial harm to the competitive position of the people who you got it from? It's a fairly simple test. If it's proprietary information, if it's secret sauce, what have you, then you have to apply that analysis. Next slide. Exemption 2 is the personal privacy. This is the one. This is the one that involves the greatest amount of controversy, cases, et cetera. Information of a personal nature where the public disclosure would constitute a clearly unwarranted invasion of personal privacy. This is where the district's balancing test comes in, and it comes down to the balance of, is it in the greater public interest or is the privacy interest of the individual implicated greater? We do a whole separate training where we kind of do a little bit more of that, and that'll be part of our FOIA webinar series. The individual's privacy interest in the material issue must be balanced, and the public interest must serve the core purpose of shedding light on the agency's performance of its statutory duties. So it's not about, I want to know this person's information. It's my request shedding light on the agency's performance of its duties. And one of the classics is you can FOIA a successful job applicant's application or resume. But if somebody applied for the job and didn't get it, that resume would not necessarily be FOIAble because that person's privacy interest, they didn't get the job. It has nothing to do with how the agency they applied to does its work. Therefore, the test would fail. then again, the courts have applied this. So the two cases this comes from, in re appeal of Walter Thomas and in re appeal of the Washington Post, you can look those up. And again, we can direct you to those cases. But it's a balancing test. It requires judgment. It requires just, a subjective level of discretion. And then you pay your money and take your chances. Exemption 2A, body worn cameras. Next slide. This only relates to MPD. So again, I'm gonna move on from that. And if anybody from MPD or a law enforcement agency has questions, happy to consult on that. The more general law enforcement investigatory records exemption is number 3. Disclose investigative techniques and procedures not generally known outside the government or endanger the life and physical safety. This is a very niche area. Again, just be aware of it. I think most of the district agencies do not deal directly in law enforcement of any kind, and therefore it's not relevant. The few that do, they're doing specific training with us or with another agency. This is another one that comes into play a lot: interagency or intra-agency memorandums or letters, which would not be available to a party other than an agency in litigation. This gets into questions of discovery, et cetera. It's a specialized area, but if it's not something that that you would have access to, you do not have to release it, and you can apply exemption 4. If the only way that somebody could get it is to be in a lawsuit, generally. Next slide. Put 5 and 6 together. 5 future exam questions. Obviously, we don't want students to be able to access or get access to educational or certification information. Number 6, other statutes, which can be a regulation specifically exempted by disclosure by statute. We don't want records of, agencies like the fatality bodies, the maternal fatality, infant mortality, et cetera. If a statute protects those records, then you apply, because the statute specifically exempts those records. And you would say, I'm applying exemption 6 on the basis of this statute, and you would flag that in your determination. And if the statute leaves no discretion, then it's an absolute. Like that then somebody would have to file a lawsuit to overcome that. 7, 8, and 9, national security matters under federal law. We live in the district. Yes, there are situations where we could have a national security matter. Antitrust investigations. We've heard from DLCP. We've heard some other agencies. Yes, businesses. We do deal with licensing. We do deal with businesses. Antitrust is a thing. But it's, again, if it involves antitrust investigations, you probably already know how to apply Exemption 8. Arson investigations, that's fire and emergency medical, I think exclusively applies that. And that's covered at 5-417 for them. Emergency response plans. Okay, this one is increasingly relevant. Post-COVID, post other things that we've seen, et cetera. Any agency that's involved in emergency response plans has the ability to exempt those portions that relate to an agency like the office. Like when we have an emergency where this office goes, our emergency response plan is exempt under Exemption 10. That is not, because again, you could have a lone wolf or a bad actor who's trying to target by getting that information, and we don't want that to happen. Major Social Security and federal employee ID numbers under 11, obvious, those things always need to be redacted, full stop. You don't want to be the FOIA officer that ends up putting those numbers out mistakenly. Exemption 12, whistleblowers, unless the name of the employee is already known. Again, if it's been reported in the wide press and it's a common knowledge thing, then you can't apply Exemption 10. Otherwise, a whistleblower enjoys all the statutory protections that exist for whistleblowers, both federal and district protections. 13, Homeland Security records, very similar to the other records we talked about. Sealed criminal records. Again, I don't know who other than a law enforcement agency or a court would have those. And then critical infrastructure. That only applies to the entities regulated by the PSC. So that's going to be your power companies, your water, et cetera. This is to prevent people interfering with, our key resources, our key infrastructure resources. Teacher evaluations, that's protected under Section 38. That has to do with, I believe that comes from out of the collective bargaining agreements, and protects those. Now let's go to the next slide. Now let's talk about common law exemption, or common law privileges / exemptions really quick. Attorney work product applies to documents prepared by or for an attorney in anticipation of litigation, no matter where that is. If you're anticipating litigation and you have a good faith anticipation, if you're in the midst of a litigation, if you are post litigation and anticipating an appeal, then the attorney work product can be invoked. Common law privilege. Next slide. Attorney-client privilege protects confidential communication between an attorney and client when the agency is the client and when privilege is necessary. For those who are familiar with the Open Meetings Act, which, as I've discussed, we handle in this office, the reason that consulting with an attorney is available in closed session to a public body is this exactly. The common law presumption is that an attorney and client can communicate about legal matters where it's specific legal advice by the relevant attorney, and that is protected. And again, you can apply that where appropriate with a FOIA exemption and redact that information. Redact it if it's part of a document that has other information. If it's purely something, then you can withhold. Deliberative process is the method through which an agency creates its policies and regulations. The record has to be pre-decisional and deliberative, which means the records are discussing what are we going to do, what should we do, what rules should we create, what determination on this should we come to. Once a decision is final and publicly known, you cannot apply the deliberative process privilege. It only applies to pre-decisional and deliberative records. Next slide. Third-party communication deliberative process. Deliberative process does not generally apply to communications that include third parties. So 2-53484 applies only to intra-agency documents. So you probably are not going to be able to apply the exemption when there's a third-party communication going on. They can only be withheld under the deliberative process privilege under what's called the consultant corollary. If the third party has no independent interest, i.e. their interests align with the government. So a third-party agency who is operating and their interest is the same as the client or the government, then you would look to the consultant corollary, but that's the only case where you would apply it in the case of a third party. Next slide. In the typical case, the consultant does not represent an interest of its own or the interest of any other client when it advises the agency that hires it. So in other words, it's a dedicated consultant function. The government is its only client, and therefore the government's interest and the consultant's interests are aligned and the same. So essentially, they're constructively an employee of the government, although they're referred to as the consultant under the corollary. Next slide. GLOMAR responses. For anybody who knows what this is, I don't know for DC where a GLOMAR response would apply. People ask me about it occasionally. Very quickly, it is essentially even acknowledging that records exist would divulge protected information. This comes from a national security issue with a downed submarine 50-something years ago, where the government said even acknowledging the existence of this thing would do damage, and that became what is known statutorily. But you've got to use caution because a search, it may not be required. All the records are entirely protected, but requests can include responsive, non-exempt records. So you still have to do your full analysis. And I struggle standing here before you today right now to think of a GLOMAR response FOIA request that I've seen at our level. Probably not. All right, next slide. Producing the records. We're going to flip right along. You do not have to provide answers to requesters' questions that are disguised as a FOIA request. Your obligation in meeting a FOIA request is to provide access to the records requested, period, full stop. And that again comes from a federal case, Dugan versus DOJ in 2015. So and again, how is it disguised as a record? There's a question. There's various ways. We don't have time to get into all that. But if somebody says, I want the following records, that's fine. If somebody says, I want the records that tell me or that will support my conclusion that A plus B equals C, that's a question disguised as a FOIA response. You do not figure out what records tell somebody that A plus B equals C. I want date range, emails, records that mention or do or these that I've identified. That's it. Next slide. And the other thing is you do not have to create new records. So in response, same case, you do not have to create a document or an opinion in response. It's the records. You send a determination. Please see below. In response to request ABC 123, you requested the following. We had 15 days, possibly plus the 10-day extension attached to your records. Done. You don't have to weigh in on it. You don't have to expound. And you certainly don't have to put them in a new format. Like, I want you to take this data and put it into a spreadsheet and organize it as follows. That's creating a new record, and you are not required under the law to do that.
I think you just answered. My question was related to electronic records. So in the course of doing business, I reach out to, in the course of doing business, our IT folks our data folks maintain records as needed for day-to-day for what they need. But often when people are asking for certain records, they probably can do it, but it's not something they maintain or create in their regular business, in their regular day-to-day operations. So when I reach out to them and say, she's like, yeah, we could probably do it, but it's not what we do. You know what I mean?
Yeah.
It's not a record that we use.
If it's not in a form, if they don't maintain it,
Like they have to run a query, and I don't know how far I should push them to say, go ahead and do the query, because they push back and say, that's not a report we even need.
Well, right. So in that case, then a report that's not generated is a record you can't fulfill. But if the requester says, I want the data that would underlie that report, then that's a record. But you only have to give it to them if it's not eligible for exemption, not common law privilege, not et cetera. And you only have to give it to them in the format that it exists in.
That's what I'm saying. They have to run a query sometimes to even make it. So the answer would be, we don't maintain it that way.
Now, so to your point, if it's not possible to export in the form that it is, that gets into a gray area that gets into not something that we can just give you a black and white definitive on. It may be that running the query, and bear in mind, I didn't say this because it's a smart group of people. I know a lot of the people online, and I see the people here. In your best estimation in good faith, you do not have to withhold records just because you can. You need to use your best judgment. If you determine that there is no reason not to fulfill a records request, even though you could, you can. So if you say, hey, there's a researcher, they're looking for this data, it's not structured in a way that I can just provide them a PDF or what have you, or an Excel spreadsheet. If you're okay with saying to your IT folks, run the query so that we can provide this data in a form that they can use, and you're not violating anything, there's nothing that says you can't do that. It is not incumbent on you to deny as a presumption. It is simply that the exemptions and the privileges and what have you, and the tools of redaction are available to you where it is in the public's interest to do so. So that gets into an area where, yeah, some databases, some things, and you can also consult the requester and say, can you ask for the information a different way? Can you work with me on that? You may get buy-in. It's an excellent point. Okay, next slide. Decision letter. Next slide. All right. So just like we have the acknowledgement, we have the agency decision letter. The things that have to be or should really be in there. Whether the record was released in full, partially released, and or redacted, or withheld in full. Name and contact information that made the decision. You're signing the letter if it's a letter and or an email, but you need to include that. If the decision was made from somebody higher than your level, you should probably disclose that at that stage. In my case, unless I have to go to a director within Bega, et cetera, then I've made the determination that it's my name. A reference to the DC code provisions that is the basis of the decision, that's in each case. So if you have 20 things that are withheld, you need to point it to 20 places in the code where that basis for the withholding or the exemption applies. And then a statement advising the requester their appeal rights. Mayor's office has a page that describes administrative review and filing a suit in Superior Court. And we can certainly help you with that. It's basically 2.5 paragraphs worth of, a few sentences and the right address and the format that the MOLC wants to see an appeal in. And that's all you have to do. And as long as you include that, you've met your requirement. Here's the things to not do in a decision letter. Next slide. Do not use language such as if construed as a denial. If you're denying the request, then say you're denying the request. There's no point in creating ambiguity or confusion. You have the right to deny where you're denying, if you're denying in good faith, and you have the right to, make sure that all your language is accurate. And don't withhold multiple records using multiple exemptions with one sentence. That is just bad practice. Here's the exemption. Here's the line across that says this relies on 2-534 subsection A. The next one, have the line go across or have it tagged, same thing. That way people can deal with each individual issue separately and they don't have to, break apart a complicated sentence. So here's the process in a nutshell. Next slide. Receive the FOIA request, process it, log the request, create the case file, estimate the fees, send the acknowledgement, then retrieve the record, search for them, request them, review them, do your thing, process them, make the redactions, apply the exemptions, calculate your fees. Then finally, approve the release of records or deny, draft the response letter, release the records after receiving the fee, if applicable, et cetera. Second to last slide. Go back. Oh, yeah, that's fine. So before we get to that, we'll take questions and answers. Online, I'm looking to my colleagues. Do we have any further questions that haven't been addressed? No? Okay. And in-house, do we have anybody here? I see your question. Okay.
I have a question on text messages. Our agency has never processed one for text messages. So is there like a process when a requester is wanting text messages, kind of like with Octo ESR? Is there like a form we submit out? We're wanting text messages on government?
No, there's not. This is brave new world territory in the last, I'd say, 7 years. There's a mayor's order that relates to this. We've provided advisory opinions on this. Essentially, the bottom line is that those text messages, if they are in the conduct of public business, are records.
Right.
How you obtain them from the people you've identified as having those records is not clearly established. There's no blueprint out there for that yet, but they are. If somebody says to you, those are my records, they're on my phone, again, that's something you need to take up with your general counsel and or your agency head if you've identified that there are text messages. Now, if there are text messages on the work phone, the government issued phone, then Octo probably has a process. It's probably similar to the ESR process. I've never had occasion to avail myself, so I can't say, but either they have a process or what you would do, you would reach out to the employees and say, you are to search for the following. And if you've identified any text messages, you need to, however you determine to do, take screenshots or what have you of those records for me.
Okay. And then if the requester didn't supply phone numbers or names, but put entities of Sandy Patel's communications with X LLC, is the burden on the requester to provide those names and the phone numbers in order for us to do a reasonable search? What they push back on that being like, well, you would know what they are.
If they don't say all, then that's not reasonable on their part. If they say every employee of agency A that has had any reason to deal with this contractor, I would still try to work with that requester to get specificity and to narrow. If they are absolutely intransigent and refuse, that's a FOIA request. immediately invoke the extension. And additionally, yeah, you might run into some problems in terms of fulfilling the requests in the statutory period of time. But again, we all send text messages, we all send emails, but the truth is responsive messages, the FOIA officer does not need to review everybody's text logs. The FOIA officer needs to indicate to the relevant individuals, this is what is being searched for. I am advising you on these parameters. You are to report back to me with the records. The burden is not on one individual. It is the team effort. The FOIA officer is just the central mind and coordinator at the narrow tip of the spear.
Thank you.
Another question?
Not actually a question. Henry Johnson, I'm with EOM. We get a lot of requests for text messages. I can confirm that Octo does not have a process.
Do you mind if we talk sidebar?
Absolutely.
Thank you.
And repeat what you just said, because I mean, I'm here and I couldn't hear, and I don't know if folks online could hear it.
Oh, sorry. I'm aware because my agency has gotten a lot of requests for text messages that Octo does not have a process in the back end.
Okay, and that was my thought, but I didn't want to say definitively. So you would in fact be a central coordinator of an organic process that you would go through to identify those records, and that is unfortunately part of the nature of the FOIA officer process. Next slide. And again, this deck will be available probably as soon as tomorrow. Contact slide. That was 2 or 3 before. Yeah, there we go. So this is us. 202-481-3411 is our main line, or OpenGov office at dc.gov is our main inbox. Here's our staff. The entire OG staff is here. Director of Open Government, Cal Allen, Chief Counsel Louis Neal, our trial attorney Brandon Lewis, the other attorney advisor besides myself, Joan Lelma, our paralegal specialist Kimberly Brown, and our IT specialist Kevin Brown. We are here to assist you. We do assist the public, but our primary charge is FOIA, and relative to FOIA, is to assist FOIA officers in the fair and reasonable and efficient application of FOIA. So feel free to reach out to us. Those are our names. We're all on teams, and we look forward to answering any further questions, and we would certainly like to invite anyone online and obviously everyone here to feel free to join us shortly at Stan's Restaurant on Vermont Avenue. We will socialize, happy to talk shop, and happy to answer questions. But if folks just want to visit, we're happy to do that as well. And I think there's another question or another.
No, it's not a question. I was just hoping if each FOIA officer could come and sign in, just put their name, their agency, and email address. Thank you kindly.
Okay, so we'll take care of that. For folks online, we hope to see you shortly. If not, have a great day and feel free to reach out to us. And as the director reminded us earlier, remember next week that Emancipation Day is occurring on Thursday. So everybody have a great Emancipation Day. And with that, we thank you.